the security people, and you'll be directed somewhere else. Secondly, please speak into the microphone when providing your comments today, and make sure that it's turned on and that the green light is lit. And begin by stating your name and affiliation. Thirdly, and most importantly, please take a moment, put all your noise-making devices to silent, vibrate, do not disturb. Any housekeeping matters? All right, I believe we will begin today with Ms. Meserve completing her cross-examination of this panel. Then we will ask petitioners if they would like to request any redirect, and after that, we will then go to presentation of petitioners panel 3 witnesses, which I believe Mr. Mizell has estimated to take about an hour. And then after that, I will ask for those who wish to conduct cross-examination to come up and provide me with a time estimate. And based on that, we will plan out the next few days, perhaps even the rest of this week. So with that, Ms. Meserve, the mic is yours.
Good morning, OSHA Meserve for Land and Friends of Stone Lakes. I'm going to go ahead and begin with some questions regarding the 1143 second revised.
And actually, since I have you, why don't you go ahead and just give us an outline of the remainder of your cross? So 1143.
1143 second revised, and some of these may also go to the supplemental EIR as areas that we're permitted to ask about due to the new information.
And Ms. Meserve, you need to get closer to the microphone.
Sorry.
I see Debbie making faces at you.
Okay, great. And so pretty much all the questions go to that and the modeling assumptions. And I'm not quite sure which of the panelists will be answering them, honestly. So,
all right.
So to begin with, for Ms. White, to begin with, I think, was the Bureau involved in developing DWR 1143 second revised?
We were certainly involved in developing all the assumptions, but we did not specifically draft the table.
But the Bureau reviewed the table prior to its submittal?
Objection. This is beyond the scope of Ms. White's testimony.
It goes to 1143, overruled.
I definitely reviewed the table. I don't know the date it was submitted and whether or not that was before. I apologize.
I'm sorry, I couldn't hear you before.
I said I definitely reviewed it. I don't recall whether or not I was reviewing it prior to it being submitted or not.
So at some point you reviewed the DWR second revised, but you're not sure when in the time frame of submittal?
Correct.
Is it your understanding that DWR 1143 second revised assumes that the Bureau would comply with the new criteria in the proposed action on pages 3 through 6 of that table?
Can you repeat that question and maybe bring up what pages you're talking about?
Sure. So DWR 1143 second revised, if we could bring that up. And then pages 3 through 6 are labeled new criteria included in proposed action. So the question is it your understanding that DWR 1143 second revised assumes that the Bureau would comply with these new criteria that are included in the proposed action, pages 3 through 6?
Objection. We're heading somewhere way beyond the scope of Ms. White's testimony. Ms. White is here to talk about storage and release restrictions on CVP reservoirs north of Delta, and supportive of Ms. Parker's analysis of that.
And if I might add, DWR 1143 was finalized by DWR, and in our submission cover letter, I indicated that the witnesses who would best be able to speak to the content of 1143 are Dr. Jamakuri and Mr. Reyes.
So noted, but the intent of DWR 1143 is to convey, or at least help all of us better understand the operating assumptions for the proposed project, which is to be jointly operated by both petitioners. So I believe it's fair game for Ms. Meserve to ask Ms. White, or Ms. Parker for that matter, these questions and answer to the best of your ability, recognizing that you did not perhaps have a specific role in developing the actual document itself. I believe Ms. Meserve's questions goes towards to better understand how or to what extent you agree with these proposed operating criteria that was submitted on behalf of both petitioners.
My understanding is that Reclamation and DWR will jointly operate the water fix and the remaining system to comply with all applicable regulations, and including those in this proposed action.
And then on page 7 of that table, there are existing Delta criteria listed. And is it your understanding that the Bureau would also comply with those existing criteria?
Objection asked and answered. We've been through this multiple times regarding D1641, et cetera.
Ms. Meserve, it is at least my assumption, and based on now Ms. White's answer, that indeed both petitioners are proposing jointly these criteria to which they will operate. Are you trying to get at something else?
Well, I'd like to test that using the exhibit NRDC 204, which is a letter from the Bureau. If we could look at that on page 3, and it states on page 3 that State Water Board, in the middle of the page, does not have unfettered discretion to impose regulatory constraints that interfere with the congressionally authorized purpose of a reclamation project.
So to the extent that Ms. Meserve wants to test whether or not Reclamation is actually proposing the operational criteria indicated in 1143, a direct question could get to that answer. When it comes to asking questions about federal preemption opinions of the Department of the Interior, that is well beyond the scope of 1143, the supplemental document, or any of the testimony of the witnesses before you.
And I would like to add, this is a letter regarding the San Joaquin system, and we went over that in great detail yesterday about whether or not the San Joaquin system is relevant to this hearing.
I think my questions are a bit more broad, actually, where I'm testing the ability of the Bureau in this hearing, the ability and intent of the Bureau to comply with State Water Board requirements, given the statements that have been made in this recent letter, which, although the subject matter may be a standard that is in the San Joaquin system, it makes some very broad statements regarding the Water Board's ability to impose requirements on the Bureau. And we've been told throughout this hearing that the Bureau would comply with all applicable requirements. So that's why I'm bringing up this issue.
And
Ms.
how are
White,
you tying it specifically to 1143? Or to something that is within the scope of rebuttal testimony, or this Part 2 rebuttal phase? I understand we had this sort of discussion yesterday, Ms. Meserve, and you will appreciate that as much as I don't make up the rules that govern these proceedings, I must adhere to them. And one of the rules is that the scope of rebuttal cross-examination must be within the scope of rebuttal, or in this case, we have identified that to be rebuttal testimony, DWR 1143 second revision, or the supplemental EIR EIS?
Correct. So the 1143 second revised spends several pages on new criteria that are proposed to be included in the proposed action, and that would likely become conditions that the water board would impose in a permit granted. And then in addition, it lists existing criteria that come from the water board. So I believe 1143 includes this idea that the water board has authority to impose requirements on the Bureau. And if the Bureau's position is if that is not true, then I think we all need to know about that.
All right, hold on. Let me hear from Ms. Morris first, and then I will get to you, Mr. Mizell.
Thank you. I would just, a couple of points. I would join the objections. This is beyond the scope. This letter is dealing with water quality.
I'm sorry, Ms. Morris, when you say beyond the scope, you are saying beyond the scope of rebuttal?
Correct.
Okay.
And it's beyond the scope of rebuttal. In addition, the water quality control plan standards are different than what's in 1143. 1143 contains criteria related to biological opinions, which are separate, and Ms. Meserve is trying to conflate what goes in water permits versus water quality standards, which this letter clearly is only talking about water quality standards and the applicability to the federal government.
Mr. Mizell, anything to add?
Yeah, I'd like to add that to the question Ms. Meserve is asking, Ms. White has already given a very direct answer, so I believe it's asked and answered. Again, to the federal preemption issue and what is raised by this, it's a legal conclusion that does go beyond the scope of any of the witnesses' testimony.
Ms. Stauffenberg.
And I would just like to add that this letter is also specifically pointed at New Melones, and Ms. Meserve is painting with extremely broad brushes about the meaning of the other statements in this letter.
Anyone else wanting to weigh in? Ms. Meserve, last words?
Well, I mean, I think that if we look at the existing Delta criteria, the modeling assumptions column on page 7 is referring to D1641. And again, I think all the new criteria would likely become part of a permit that could be issued by this board. So it's a very real concern about whether the Bureau, as stated in this letter, may have the would have the U.S. Attorney take action against the Water Board rather than comply with requirements that the Water Board had imposed for this project.
All right, Ms. Meserve, thank you. Thank you all for your input. As I said yesterday, this is outside of the scope that we have framed for Part 2 rebuttal, and therefore outside of the scope for cross-examination. However, as I mentioned when Mr. Jackson eloquently talked about this yesterday, you've certainly raised an issue that we will be considering. It is not appropriate for cross-examination during this rebuttal phase, but we will give it some thought, we will take it under consideration, and at some point we will be addressing it. But for now, the objections are sustained. Please continue with your next line of questioning, Ms. Meserve.
Thank you. With respect to Ms. Parker's testimony on the third paragraph of the first page, you refer to the regulatory requirements. Let me see if I can get there. Including its regulatory obligations, rather. And my question is, if GWR second revised does not account for the split between the CVP and the SWP, as was discussed yesterday, how will DOI ensure that the diversions in the proposed North Delta area are within DOI's water rights permit limits?
Objection beyond the scope of, who was that question for?
It could be anyone. I had tried to tie it to Ms. Parker's testimony. It's really an 1143 question.
Hope we understand the question.
Yesterday, there was discussion in the context of the float, the split, and Ms. Parker was discussing the fact that the model doesn't care where the water comes from. And so my question is, how does the model, or how would the project ensure that the diversions are within the water rights permit limits of the Bureau if there's no information in the model about where that water is coming from?
Ms. Parker?
I'd like to also object. The operations, day-to-day operations that monitor the quantities of water and the places from which that water is diverted are not a subject that's before you with this rebuttal testimony. 1143 goes to the operating criteria, which are conditions proposed on the project, goes to modeling assumptions as to how the model interpreted those criteria, and then talks about permit conditions from the fish agencies. At no point does it go into how the operations on a daily basis account for the water that is diverted from the existing projects or under the California water fix.
How does the modeling account for it?
Well, this goes to the float issue. So the extent to which the model
Are you
accounts-
testifying or?
No,
Let me ask Mr. Reyes that.
I'm explaining my objection. My objection is it's beyond the scope. I'm happy to elaborate if you need it.
It's not beyond the scope because we're trying to understand what is encompassed in 1143 and what it isn't. So, Mr. Reyes or Dr. Chilmakuri, now that I finally can say your last name, could one of you answer that question?
The model is complying with all the regulatory criteria, including the water right
So
limits.
it's built in.
Yes.
So does it include then a maximum amount that can be diverted under a CVP label in a given day,
In a month, yes.
in a month? And is that, do you know where that reference would be if I wanted to follow up on that?
What specifically are you looking for?
Where is that assumption in the model so we could be assured that it's true that there's some kind of limit in the model? Because the discussion yesterday from Ms. Parker made me think maybe there wasn't, and that's why I asked the question.
You can look at the biological assessment, Appendix 5A.
Of the final EIR?
Biological assessment.
Okay. Now, on 1143, both footnote 29 and 38 refer to changes under adaptive management. That we've discussed a little bit. Doesn't the ITP state that all criteria are subject to change under adaptive management?
Could you point us to that, please?
So that would be in SWRCB 107, top of page 67.
And your point in asking this question relative to 1143 is?
So the issue is that there are two footnotes, one with respect to spring outflow and one with respect to South Delta operations that talk about changes under adaptive management. And my questions go to the issue of what all is subject to adaptive management.
So you're asking whether or not other criteria as proposed in 1143 might also be subject to adaptive management.
Yes.
Let's ask that rather than pulling up the ITP again.
Okay, yes. So I guess, Dr. Chilmakuri, is it your understanding that all the criteria in DWR 1143 second revised would be subject to change under adaptive management?
Yes.
So just to be clear, it's not limited to South Delta operations and spring outflow?
That's my understanding. All the criteria are subject to adaptive management. It's all encompassing.
So does DWR or the Bureau intend to correct DWR second revised to reflect that more clearly?
Objection, argumentative. DWR
Well, hold
1143
on.
revised 2 states which criteria are currently considered within adaptive management processes indicated in the fish agency permits. I don't believe anywhere in 1143 it says that that is exclusive.
Dr. Chill McCurry, your response to Ms. Meserve's question regarding adaptive management.
Could you
In your
state-
understanding, how is that reflected in 1143? Revised revision 2.
It's, there are, as Ms. Mizzou pointed out, there are 2 footnotes that are specific to 2 criteria, but as I understand adaptive management, and I'm in no means an expert on adaptive management, but my understanding of it is it encompasses everything. If the best available science indicates a change is necessary, I think that adaptive management is it's providing a way to adapt the criteria. And in my opinion, all the criteria are subject to it.
Right.
Okay.
You've made your point, Ms. Meserve.
Okay. Footnote 38 refers to the DFW concurrence and coordination with Fish and Wildlife Service and NIMFS with respect to changes in spring outflow. Is there any role for the State Water Board in making a change to spring outflow requirements using adaptive management?
Again, I'm not fully familiar with the composition of the group who would make those decisions, but you can follow up with Mr. Earl or Dr. Earl, who's coming up in the next panel.
So just to be clear, we would be permitted to ask Dr. Earl questions about DWR 1143 revised?
And the question specifically was?
Whether there would be a role for the State Water Board in making changes to spring outflow requirements?
And how does that, I mean, that's a question with or without 1143.
Well, I mean, for me, it's related to 1143 because I've
Right.
noticed, like we've talked about, usually in legal proceedings, we only put,
Well, let me put it this way, Mrs. Earth. That question, yes, I don't want to open 1143 to everybody on panel 3. So depending on the circumstances.
okay, thank you. Is anyone on this panel aware of any role for the State Water Board in any other changes that may be sought through the adaptive management process? Okay. There's no answer.
Well, can I add, I think it just depends on what it is that's changing. I mean, a lot of these criteria are kind of overlapping with other criteria that already exist. So I think it would really depend on specifically what we're talking about, but possibly panel 3 would be able to expand on that further.
Okay. So if we could look at page 7 of 1143 revised on the last row. And this is looking at the export to inflow ratio. And it defines the Sacramento River flow as flows downstream of the North Delta diversions, such that the North Delta diversions are not included in the calculation. Doesn't this move the compliance point for calculating inflow for export to inflow from Freeport to downstream of the North Delta diversions?
Ms. Morris?
Objection misstates the testimony. It doesn't say that it's moving a compliance point. It says specifically on that they are requesting or suggesting, which is different than saying they're moving the compliance point.
All right. object, we'll caveat it that way.
I have another objection. This was discussed extensively in part one. I believe Armin Munavar attested at great length about the export-import inflow ratio. So this has already been a topic of cross-examination for quite some time.
Thank you. I recognize that, but now it's being asked in context of 1143. So Ms. Meserve, please repeat the question, noting the caveat that Ms. Morris reminded us of.
Certainly. So this export to inflow ratio that is listed as under key existing criteria of the table would actually be a change from the current calculation of export to inflow at Freeport, wouldn't it?
We can bring up D1641. I don't believe this is a change in how the EI ratio is being calculated. All we are saying is that for Sacramento River inflow, the flow should be downstream of the intakes, given that there are other protective criteria for the entrainment, such as the bypass flows for North Delta diversion and Old and Middle River flow requirements for the South Delta intakes.
And the ITP defines the delta inflow as including that water that goes down the Yolo bypass also, doesn't it?
Again, you have to show me where and what context that was discussed or defined.
If we need to go to the ITP, that's SWRCB 107, page 181. And on that page, it states that the delta inflow is defined as the sum of the Sacramento River flow downstream of the North Delta intakes, and the Yolo bypass flow is included there. At the bottom of the page, yes. Do you see that?
Yes, that is the existing definition of the inflow in 1641, I believe.
Right. So are you aware that under implementation of the RPAs for the 2009 biological opinion that it is proposed for more water to be put down the Yolo bypass than currently goes down the Yolo bypass?
Objection.
Mr. Mizell?
Beyond the scope of testimony 1143 in the supplemental.
So link it back to 1143, Ms. Meserve?
Well, I'm focusing on the export to inflow ratio
Yes, but that question,
and digging into that using the ITP, it's assuming that also downstream of the North Delta diversions would be any water that went down the Yolo bypass. And so I want to ask Dr. Chilmacurry or Mr. Reyes about whether the model accounts for the increased flows down the Yolo bypass that are going to occur under implementation of the 2009 biological opinion requirements.
and how does that tie back to 1143?
Because the 1143 lists these adopted project criteria and the modeling assumptions, and my questions go to whether the modeling assumptions include that increase in flow down the Yolo bypass, which is well underway.
As depicted in 1143, as a proposed criterion.
Yes.
Okay. Ms. Morris?
I'd just like to add the objection that this has been asked and answered, that the criteria for this export inflow ratio has not changed throughout the proceedings. So there has been no change from what's in 1143 as to what Mr. Munavar already testified to and explained to in part one.
I understand, but one of the purpose of 1143 is to help all of us better understand the complexity of what's being proposed, especially the operating criteria and the modeling assumptions. So I'm going to give her a little bit of leeway on that. Please answer. It's not like she's reopening everything in part one. So this is an important point. Dr. Chilmacurry?
The no action and the water fix modeling that was presented to you in this hearing Both include a change to the existing Fremont Weir. It assumes there would be a new notch, and that there would be higher flows going into Yolo bypass through that notch at lower Sacramento River flows. So the modeling includes that a representation of the action that's being considered. I wouldn't say that the action that was included in the modeling is exactly the proposed action for that project. I don't know the proposed action exactly, as far as we have a representation of that project in our modeling.
Isn't it true, Dr. Chilmacurry, that the modeling assumes only up to 6,000 CFS going through the Yolo bypass?
Ms. Morris?
Yeah, it's vague and ambiguous as to the time or that could differ. So if she could be specific as to what time frame she's asking about, that would be helpful.
Ms. Meserve?
Trying to avoid bringing up a lot of documents here. Period of inundation in the modeling, doesn't it include December 1st through April 30th, maximum of 6,000 CFS?
That's through the notch, and the water would spill over the current weir still. So if there is sufficient flow in the river, the spills would be much greater than 6,000. The 6,000 is only to the it's the limit to the amount of flow that would be allowed through the notch.
Isn't it true that the Yolo bypass project is considering a flow up to 12,000 CFS over a longer time period?
I don't know.
So are you aware of whether the modeling attempted to track the development of the implementation of this portion of the NIMP's biological opinion?
Yes, I would agree. I would say that we were attempting to include a representation of that action from NIMP's biological opinion. However, as far as I know, the Yolo bypass process, I believe they just released the draft EIR early this year or late last year. So we were much far ahead with respect to water fix, and we had to make an assumption as to what that action would be. And let's just say that this assumption was developed in coordination with fish agencies within the water fix context.
But it's possible that the amount of flow going through the Yolo bypass could be higher than was assumed in the modeling. Isn't that correct?
Objection. Calls for speculation.
And now you're getting into way details that is beyond the scope of 1143, Ms. Meserve.
The reason why I'm asking these questions goes back to the water rights questions, because if the water quality is different in the modeling outputs than is likely under this implementation of a requirement of the 2009 biological opinion, that will affect water quality for all the water users downstream of the Yolo bypass.
I appreciate that, but that is beyond 1143. And it's also not in anyone's rebuttal testimony. And I don't think it's part of the change in the EIR supplemental, so you've exhausted the three options here.
Well, the relationship I did think of with respect to the supplemental EIR is that both the water quality, the water supply, and the chapters 5 and 6 include no further discussion, including of cumulative impacts. And in the time period since the certification of the final EIR, there has been more certainty about the moving forward of this Yolo bypass project. And so I believe
that's still outside the scope.
I thought we were able to ask questions about the supplemental EIR, and my question.
And the changes as reflected in the footprint.
I think my question goes to whether there should have been a revised cumulative impact analysis given the moving forward of the YOLO bypass project.
Outside the scope. Ms. Womack.
I would concur with Ms. Meserve. Our impact of water quality, since we're now that our ranch is not being taken, our water quality, we worry about a great deal and all the impacts from all of the things. So I would appreciate having more details about the water quality. There wasn't much in the supplemental that I could glean that was how it was going to change, improve my water quality. I am a licensed, user of water, a legal user of water, and my water quality is, I haven't seen where I'm assured that my water quality is not going to suffer. So I appreciate Ms. Meserve's questioning.
Your appreciation is noted. However, it is still outside the scope of rebuttal cross-examination.
Okay. I'm going to move on to some questions about the regulatory requirements in DWR 1143. If we could, for I believe Ms. Parker, the San Luis rule curve that you discussed in your testimony, it reflects a discretionary element of project operations, doesn't it?
Before you object, Ms. Offenberg, I know we've been through this, so I'm sure Ms. Meserve has a point that she'll get to very quickly.
Would you please tell me where in my testimony you're looking? Remind me of that.
I think it was more of your response to cross-exam rather than in your testimony, as I remember it.
Okay, I'm sorry, would you refresh my memory as to my comment?
I believe that it was discussed that the San Luis rule curve is a discretionary element of the project operations for the Bureau.
Okay, I remember that now, and so please repeat your question.
Just that it is a discretionary element. I'm just confirming
and
what
answered.
you said before.
Okay.
Yeah.
Your next question.
And so that relates to moving water from north to south?
The rule curve is a model mechanism that governs how the model moves water from north to south. It's not an explicit representation of Central Valley operations, actual real-time operations.
Okay. I'd like to put up an exhibit, FSL 60. This is a letter of interest in funding regarding WIFIA, and I'm specifically referring to page 23 of that document. And I have paper copies that I can provide for at least some of the witnesses.
What is WIFIA?
Water Infrastructure Financing Program.
Ms. Morris?
I would just object that this document is outside the scope. This has to deal with a letter of intent that was submitted by a finance JPA, none of which is
Ms.
a
Morris,
bureau.
I don't know yet what her intent is to bring this up, so let's let her ask the question, and then I will listen to any objections.
Okay, so I'm looking at the third paragraph on page 23. If Ms. Parker could and Ms. White could take a look at that paragraph that discusses an agreement being negotiated.
And make the linkage for me, Ms. Meserve, in terms of how this relates to either their rebuttal testimony, 1143, or the supplemental EIR.
I think the relationship is that this has to do with the model logic that was in 1143 and omitted from 1143. So, such as the rule curve and setting the export allocations. So we're trying to look at what the operational discretion is going to be in this project. Go back to our issue of what's included in 1143 and what's not. I think this is an example of something that's not included in 1143 that appears to bear on the operations.
Okay.
I'd like to object is to the assertions Ms. Meserve is making that a financing JPA proposal that we have no knowledge as to whether or not it's been accepted or incorporated into the project has absolutely no bearing on what the existing rule curve assumptions are in the modeling.
Ms. Morris?
And I would object, this lacks foundation. There's no basis. There's been no showing that these witnesses are familiar with provided information or that that statement is in fact based on any modeling.
Everyone just hold on. Ms. Meserve, what is your question?
My questions have to do with whether the DOI witnesses or others on the panel are familiar with the agreement referenced here.
Up, all right. Anyone? Ms. Morris?
I would object on the basis that to the extent any of the discussions regarding this agreement are confidential.
Okay.
And
We
I'll
won't
just-
get into confidential matter.
This is a public document.
Again, is anyone familiar with this document and this?
I have never seen this document.
I'm not familiar with this document, no.
Me neither.
I'm not familiar with it.
All right, Ms. Meserve, it doesn't seem like anyone is familiar with it. Mr. Becerra?
I think the question actually was whether any of the witnesses are familiar with the ongoing negotiation between DWR and Reclamation that's described here. And I believe at least Ms. Parker in the past has previously stated she is familiar with that. And I believe in her previous cross-examination responses, she stated that the results of that could affect how operational discretion is exercised in relation to water fix.
Yes, but this specific document references financing.
Well, yes, the questions
Negotiation.
don't refer to financing. They refer to an agreement that is establishing apparently new criteria about avoiding impacts to CVP water operations. And so again, back to 1143, we're trying to understand whether 1143 really represents the entirety of the requirements that this project is proposing to meet.
And I'd object
So
as
to
Ms.
your knowledge, people sitting there, does 1143 reflect all the operational criteria being proposed by the projects?
Hearing Officer Dodick, I'd like to be very clear with the answers the witnesses will give to your question is we want you to have all the information that you are seeking. However, they've all indicated they have no knowledge of this document. It will be extremely hard for them to answer without speculating as to whether or not specifics contained in a document they're unaware of are contained in the modeling.
Understood. Ms. Tabor, you've been jumping up and down.
I just want to make sure I understand when we're talking about this document and the witnesses' familiarity with this document, if Mr. Mizell is referring to the document on the screen or the agreement referenced in that document. It's my understanding that Ms. Meserve's questions go to their familiarity with the agreement that is DWR has represented in this document as being negotiated. And so I'm not sure that we're all talking about the same document.
All right,
Maybe Ms. Meserve could make that clear.
Ms. Meserve. Actually, what is your question? I mean, I appreciate that councils have the right to object and others have the right to jump in, but it does confuse the matter when I'm trying to understand the point you are trying to get at, Ms. Meserve.
Right. Well, I mean, I think in general, I'm trying to understand how to square the statements in this document and the discussions that appear to be underway according to the representations in this document.
Okay, stop. When you say this document, you mean?
FSL 60, which is the WIFIA
Okay.
loan application, is referring to a negotiation.
Okay, go on.
And then I'm trying to understand what the status of that negotiation is.
When you say that negotiation, are you referring to the financing aspect of that negotiation?
No. The WIFIA application discusses an agreement being negotiated that would establish criteria to avoid possible impacts to CVP.
And where is that?
So that's at the bottom of the screen. The
Okay.
last full paragraph. So going back to the questions, do the witnesses know who is involved in negotiating this agreement?
Objection, that's a different question.
Then let's hear the answer.
Well, in that case, I object as to relevance.
I think Ms. Meserve has established that she's trying to make the linkage, and let's see if there is a linkage to be made.
I'd also like to object based upon the fact that what Ms. Meserve is referencing in this document seems to reference ongoing COA negotiations. COA is been thoroughly discussed, so I'd say asked and answered.
I think in the context of COA, though, we've been discussing it in terms of something that's already set. And this is introducing a concept that there's...
So, Ms. Meserve, I appreciate where you are trying to go, but I, one, question whether there is value in pursuing it with these witnesses who doesn't seem very familiar with the specific that is being negotiated, and also because it is under negotiation, it's subject to change. So where is the value in us trying to understand this particular phase of negotiation?
Well, I think what we're interested in knowing is what kinds of impacts to the CVP this document is referring to avoiding, and then how that would affect operations.
Well, one, these witnesses are not familiar with this document and the statement about things being avoided. And second, because the negotiations are still ongoing and not yet concluded, how would they or we sitting here today determine what the impacts might be?
Well, I think part of the record I want to create is that it doesn't appear that there's a set project with respect to the CVP, at least.
So is your point then that 1143 is subject to change based on, well, is potentially could be changed based on the outcome of the agreements being discussed here?
Correct.
And I think we've got that, and I think you've made that point, and it's in the record.
I didn't quite catch, I heard the witnesses answer that they were not familiar with this particular document, and I think the part maybe I missed and they answered was whether they were involved in the discussions about the impacts to the CVP that are referenced in the document.
Let's get this over with. Mr. Becerra?
Just a quick point. I think it's a fairly simple subject. It's how much of this project is outside of the regulatory requirements that are described in 1143. What else is subject to the petitioner's
Yes, and
discretion?
you all may make that point in your closing briefs, but it's not something that can be resolved with these witnesses and during this scope of this cross-examination. Mr. Jackson?
Yes. The point that I think is relevant here is that the material that is required under your regulations to be in the permit is still not, according to this document, is still not in final form. This, all the way through this, we've been responding, you've been allowing the prove up of the material that should have been in the petition to start the hearing so that we knew what was inside the operational criteria that they're relying on and what was outside. And we still don't know.
And that is an argument we've heard before.
it would be helpful if we could ask questions that are related to, I don't know what they mean by currently there's only one contractual arrangement that might affect operation of the water fix.
And since these
And
witnesses
that's
are
what
not
this is.
familiar with this document, they cannot possibly answer that question. Next.
I would just like to say that I did make, citing the example in Decision 990, which was when the first coordinated operating agreement was made. It's absolutely fundamental to the agreement between the projects, how they share unstored water, given that the Bureau's petition assumed the entire unimpaired flow of the Feather River, and DWR's application also assumes that there is a fundamental agreement about both sharing of shortages and obligation for in-basin
And your
needs.
point is, because you surely are not testifying.
My point is, I would like to make it on request that I made that as a request, and that the hearing officers follow the example in Decision 990 and recess the hearing until an agreement was made. This agreement shows how difficult it is to get any details on what is going to be absolutely fundamental to whether the water quality plan requirements are met in the future.
We have received, considered numerous motions to wait until things are further developed. Our ruling stand on that. Your request is denied. Ms. Morris.
It is an objection to the question that was just revised, and that is to the extent that it calls for confidential settlement discussion as well as speculative, as this document clearly says, may impact, and it says,
Understood.
if any. Well, the
All right.
question was revised, so I apologize.
Ms. Meserve, there is no further value to be added by this. Move on. Your point, if it was the point that 1143 is subject to change depending on a lot of things, including adaptive management, including ongoing negotiations on the COA and other agreements, is noted.
And so, am I permitted to ask the witnesses whether they agree that the operations may be changed based on the discussions about avoiding impacts to CVP, or am I permitted to ask no further questions regarding this?
I think you would get an objection about the phrasing of that question, so let's not go there. And I think, would anyone on the panel, well, actually, I will request everyone on the panel to state whether or not your understanding, which I think at least Dr. Chumakuri has already stated, that the criteria being proposed in 1143 is subject to change pending a variety of other factors. Does anyone disagree with that?
I just said, I want to be clear, my testimony was the criteria in 1143 was subject to change under adaptive management plan. I didn't say there is anything else that's going to affect. So
is it your testimony that to your knowledge, no other factors may impact the proposed criteria in 1143 except adaptive management?
that I'm aware of, yes.
Okay.
would
I
be
stand
interested-
corrected.
I would be interested in the Bureau witness's response to your question.
Ms. White, Ms. Parker.
It's hard to, I agree with Dr. Chumlakuri. Biological opinions are always subject to change based on the trigger condition, so it's difficult to say that nothing else could change this. I think in our biological opinion for Fish and Wildlife Service, there's already an expectation to consult, so I would imagine those also would have the potential to change some of the operating criteria.
The discussions about avoiding impacts to CVP could also change the operating criteria as well, couldn't they?
No, they have testified, I mean, no, I'm not answering for them. I'm telling you, no, that we've gone down this path. They are not familiar with this document, this negotiation, whatever the underlying purpose is for what's being reflected in this document that they have not seen. So we are not going to go there, and you are out of time.
Yes, but I don't think the Bureau witnesses ever agreed with your statement that they
They
were
don't have
not
to agree?
familiar. Wait a minute, though, just to be clear. They said they weren't familiar with this document. They did not say they were not familiar with the negotiations.
Are you familiar with the negotiation described in this document that you've not seen before?
I'm not really familiar with what this document is stating, so it's hard for me to answer that. I guess I can say I'm generally aware there's discussions going on between Reclamation DWR that's been testified to numerous times. I am not a negotiator for the department or for Reclamation. So
That concludes my questions.
Hearing
Thank
Officer
you.
Dodek, I'd like to make a legal clarification. You have the answers